So I'm here to talk about contracts in relation to copyright specifically. And as a copyright holder, for your own protection, it is advisable to share your work within the confines of the law, so that in case of any breach, law can be there to protect you. So the best way to do this is by signing what we call contracts. A contract is an agreement between two or more parties in simple terms. So the contract will help your creative work or service and help to give clarity to the rights and obligations of the parties, because the contract will be there to define what obligations and rights you have. So a contract may either be written or it may be verbal, but when it comes to intellectual property, particularly copyright works, it is advisable that you have written contracts, because they will help you to deal with infringement. So they can be oral or written, but in copyright we expect it to be, we advise that be in writing. So for a contract to be valid and enforceable by law, there are specific requirements that the contract must meet. They are the essential elements of a contract, the basic ones. So the first one is that both parties to the contract must have capacity to enter into the contract. What does capacity mean? Capacity means that they should be capable to enter into a contract within the meaning of the law. For example, a minor or a person below the age of 18 that lacks capacity to enter into a contract. A person who have a mental incapacity lacks capacity to enter into contract. However, there are some exemptions that relate to capacity. The second very important element of a contract is that there must be an offer. This offer comes from the offerer, and it moves to the offeree. And that offer, again, must be a legal offer and must be accepted by the offeree. So the offer, and then the offer must be accepted. So we always say that there is no specific obligation for a party to accept an offer. We have what we call freedom of contracting. Once an offer is given, you have the right to either reject it or to accept the offer as it is, or negotiate on the terms. So offer and acceptance has to be there. The third very important element is that there has to be a consideration. Consideration in a legal sense is that you must promise to do something in exchange to what is being promised in the offer. In most of the cases, a consideration is usually money, but not all times that a consideration will be money. It could be a promise to do something in exchange to that particular offer. The fourth element of a contract is that there must be a meeting of the mind. The parties must be clear on what they are dealing with. So if there is a mistake, if one party means one thing and the other party means the other thing, then there is no meeting of the word. There is no meeting of the mind, and potentially that contract lacks the meeting of the mind. Therefore, it is not a valid contract, or may be voidable or voidable depending on the circumstances. The fifth important element is that the objectives of the contract, or the purpose of the contract, must be legal. It must be within the law. The sixth element of a contract is that the contract must be capable of being performed. So whatever you are promising, whatever both parties are promising, must be capable of being performed. You must be able to perform what you are promising. Again, I'll give a very simple example. You cannot enter into a contract that you are going to make a musical work that will make congregants or a particular person to go to heaven. No, it's impossible for you to promise a person that they'll go to heaven. That contract is not enforceable. You are not able to deliver that particular contract. You may create that particular copyright work, but then that copyright work may not be what takes this particular person to heaven. It is impossible to perform that particular contract. So now, since now you know what the contract entails, or what are the elements of the contract, what are the things that you should look out for when you are entering into a contract? What are the things that you must include in that particular contract. Of course, you must have a description of the parties. For a description of the parties, you must have clear names, clear official names of both parties, including their national IDs. We advise that that be included. And during this technologically advanced period, it is important that you include email addresses. Very few people even use the postal addresses. So email address is important. So the second thing is that you must clearly describe the rights and properties under the contract. What are the rights that the contract is dealing with? What are the rights that are being transferred from one party to the other, or what are the rights that are being licensed? It has to be very clear. Are you transferring or licensing the right to make available to the public? Are you licensing the right to publish the work? Are you providing for the right to reproduce? So that right must be described, and you must describe what are the limits. You must also provide, are they exclusive rights that you are granting, or are they non-exclusive rights? The third important thing that must be included in the contract is you must include the responsibilities and obligations, the rights of the parties to the contract. What are the obligations of each of the party to the contract? It must be clear in terms of wording and clarity. Then consideration as the number 4 thing that you must ensure that it is in the contract. You must describe what is the consideration that is being provided. If it is money, how is that money going to be paid? Is it going to be paid in bits? Is it a lump sum? If it is license fee, if it is royalties, how is it going to be paid? That has to be very clear. Leave no room for guesswork in this particular contract, because that is what brings problems. So you may also include what we call a confidentiality clause, depending with the nature of the work that you are dealing with. This confidentiality clause provides for if there are secrets, or if there is information that is regarded as confidential, you may provide that shall not be disclosed. And what happens if either of the parties discloses that without the consent of the other party? It is also very important to consider including a clause that provides for amendments. How do you deal with amendments in your relationship? So within the time of the contract, it is important because things change. You may want to amend the contract. How or what is the procedure of amending that particular contract? That, ladies and gentlemen, should actually be included. Then warranties and indemnity clause. These is the consequences. You may provide for the consequences of breach of any of the terms of the contract. The term may be a warranty or a condition. Of course, the breach of a warranty does not terminate the contract. A condition will potentially terminate the contract. So it is important for you to provide for what happens in case there is a breach of a warranty or a condition or any other term that is provided in the contract. That is number 7, I believe. So if you move to number 8, it is important for you to provide for a termination clause. Most people leave these out. It is very important. It is a very important clause. Provide for if either party wants to terminate the contract, what is the procedure and what is the effect of the termination if a party intends to terminate before the end of the period that you have entered into the contract. Dispute resolution clause, that is a very, very important clause that people leave out. A dispute resolution clause will provide for how do you resolve any of the disputes under the contract. If it relates to the interpretation of a term in the contract, or if one party breaches the contract, how do you deal with that? Do you go to court, or do you go for alternative dispute resolution? Our advice is that you opt for alternative dispute resolution because it is quicker, it is cheaper. So you may include what we call a mediation clause. And mediation is the cheapest process and the easiest process that you could go through. And mediation can even take up to 1 hour, just 1 hour, as opposed to court where you can be in court for years. So consider including a mediation clause. At the Kenya Copyright Board, we have samples where you could borrow from. And the best thing with the mediation is that the dispute is you are helped to come up with a resolution on your own by an expert in the industry, an expert of your choice. So an alternative dispute resolution clause is very, very important, and we actually advise that you include it in your agreement. The other thing, because of the potential of using the work across borders, because of the technological advancement that we are under now, it is potentially possible to use a work across, or to license work across borders. And it happens, it is important for you to include a clause that provides for which law is applicable. Could be the Kenyan law that is applicable, could be the Ugandan law, whatever law that you decide, both of you as parties, that will be applicable in your relationship. The other thing is the term or duration. The duration of the contract is again very important. If you are licensing your work for a particular purpose, it is important for you to say you are licensing for a particular period of time. So negotiate that period of time and agree whether it is 1 year, 2 years, 3 years, 1 month, 1 week, and of course the territory within which that work can be used. And lastly is something that that shows that you have read and understood the contract. You sign the contract. The signature is what acknowledges that you have not only read the contract, but you have understood the contract. Once you have signed a contract, that contract becomes binding upon both of you. You cannot go to court and say you did not intend to sign. Once you sign a contract, it is presumed that you have read and understood. That is why we always advise, before you sign a contract, once you are given a contract, consult a lawyer. Let the lawyer read through the contract with you. Let him explain to you what you are getting yourself into, and let him explain to you your obligations and the obligations of the other party. Now, at the Kenya Copyright Board, we do offer these services for free. If you come to the Kenya Copyright Board, and we have experienced legal counsels who will sit with you, read through the contract, explain to you clause by clause what exactly you are getting into in the contract. And they can also advise on the issues of where you can negotiate if you wish to. And also, of course, the decision on whether to sign the contract is on you. But is once you have a lawyer has actually explained to you, it is up to you to decide whether to sign. So you can always consult the Kenya Copyright Board, who will actually advise you further on issues of that. And lastly, very lastly, we do offer mediation services for free at the moment, for free in case there is a dispute. Thank you so very much.